Well, good morning. I'm John Casper with the Oshkosh Chamber. It looks like people are starting to join the webcast this morning. We have the good folks with Von Briesen and Roper with us again for our every month HR briefings. Today it's COVID-19 updates on the relief bill, FMLA, paid sick leave, EEOC, and vaccine issues. So, and I'm sure there's a few other things that have come up over the last couple of days that weave into this. For those of you listening in, you're all in listen mode. If you have a question, please use the Q&A tab or the chat tab on the bottom of the screen, and Jim and Jill will be monitoring those questions. We're recording this session, so it'll be archived on our website, and you can go back later, and others will be pushing it out to others. So without further ado, I'm going to hit it over to Jim Macy. Jim.
Well, thanks, John, and good morning. And again, thanks to the Chamber for the continuing series that they provide. Joining me this morning is one of my colleagues, Jill Pettigo-Hall, who's out of our Madison office and part of our employment law team. Just when I always tell all of you that we're going to move on to some other topics, more things just keep coming. And as Jill and I were just talking about with John a minute ago, even this morning, updates keep coming as this law develops and as we work through the pandemic. And our job all the way through this and continuing through this is to continue this series to make sure that you're up to date as soon as we possibly can update any of you. This PowerPoint will be made available along with the recording that John just mentioned. We're always available for emails and other things too, but again, feel free to put in some questions and we'll monitor that as we go through this. But without any further ado, let's talk a little bit about some of the things that are going on here with this. As some of you know, we get to the end of the year, we're all going to relax, we're all going to enjoy the holidays, and as of December 27th, right between Christmas and New Year's, our HR people are scrambling to go, what are we going to do about these two leave provisions that were out there? When the bill was originally passed, the FFCRA was originally passed, it did have an automatic sunset as of December 31st with the two leaves, the paid sick leave and the extended FMLA. And I got to tell you, as we were all talking amongst our team, researching, talking to our contacts at the congressional office and Senate offices and other contacts through the agencies right up until the bitter end. In fact, I got to tell you, even when the 9 million page bill passed, we were scurrying through that, and some of the offices didn't even know, and I'm talking about the elected officials' offices, as to whether these leaves continued or didn't leave. The end of the day was they did not continue. Okay, so you knew that, and you didn't have that obligation anymore to do that. So they expired as of December 31st. The bill did allow for the new bill, now the Consolidated Appropriations Act, did allow for employers to continue some of the leaves if they wanted to do that through March 31st. It's voluntary, and for the private sector folks, we could still get the tax credits at least through that time period. Those leaves didn't add any more leaves, so if people had some time still left to be coming, they could use it, but they didn't extend it further as far as that goes. And the Department of Labor is still around to enforce it. What have we seen on that? We have not seen huge litigation over the application of the act. Quite frankly, the agency earlier took the position that they'd be more in a mediation mode as far as that goes and try to work people through it to avoid problems. But again, we did not see great amounts of litigation over that like we might see in other kind of forums under some of the other employment laws. Is that going to change as things change? We're going to talk about some of that in a little bit here as we go through some of the pieces. Let me give you one example though where it got a little dicey. Under the extended, and you may weigh this in terms of whether you want to extend your leaves or not, all right? But one of the provisions under the extended FMLA, and as you know, schools were closed, including the hybrid aspect of things, and daycare wasn't available, somebody could get extended FMLA. And one of the employers provided daycare to all its employees free if they had problems with their daycare and their kids were at home because of hybrid. The Department of Labor out of Minnesota, in a very limited scenario, and it never got too much other traction, but took the position that it didn't matter whether the employer provided free daycare. It left it up to the employee whether they thought that was suitable daycare. That's a problem when you start getting into these fights and potential arguments. It impacts whether you're going to extend leaves and do other stuff when you don't have to. But let's just see as time goes on with those kind of things. So if people were on the leave, they didn't get to continue it necessarily unless you wanted to do that, especially the extended FMLA and the other aspects of it. Again, as I said earlier, people can have a local policy. You can have your own employer policy. You can mirror some of the provisions of the Act. And you can get the reimbursement as a private sector person, like I said before. But there's pros and cons to do that. We're seeing a real mix as to whether people have wanted to extend it or not extend it as far as that goes. And you're going to get the reimbursement to the extent that you mirror the aspects of the Act. You have to mirror all of it? No. Our thinking is no. Is there great guidance on that, explaining all of that? No, it really isn't. But at least the suggestion suggests that you could do part of it. So for example, if you wanted to do a company policy that allowed for 80 hours of more paid leave between now and March 31st, just as an example, you could do it just for the paid leave and not the extended FMLA, okay? So if we're seeing an extended, and again, it really varies from company to company, but as to what works for you. But if we talk about as a whole, what are we seeing? We're seeing some extension of paid leave and there's reimbursement primarily, but not so much of the extended FMLA. And FMLA is different, keeping in mind that you still got to qualify for the reasons for FMLA to have it count toward FMLA. So even if you extended the FMLA leave under the narrow aspect of the school closing and a daycare issue, you're probably not going to be able to count that against regular FMLA like you could before. So just a heads up on that. The second heads up on that is, here's some case law, and we've got it cited here in the Tilley case, is the more people that weren't, before COVID, all before that, some of this case law had to do with employers that were small employers under 50, or for other reasons didn't qualify or were required to abide by the Act. If they adopted the Act, followed the Act, walks like a duck, talks like a duck, it was interpreted to mean you bought it and you get it, and you get all the applications of regulations and things that go with it. So be careful. You may want to, if you do a local policy, make it clear that you're doing a local policy, the right to change it, the other aspects of some of that as you go through it. There is some guidance out there, and we'll cite that here. And again, this outline will be available to folks as far as that goes. And those are the sites that go with those kind of things in terms of what do you do about the leaves, and then what do you do about the tax credit aspects of it. So other provisions separate from the impact on the leaves piece was the unemployment compensation supplement of 300 is in there. There's the extension of the maximum benefit period. There isn't a discussion about a reimbursement for those in the public sector aspect. That's handled differently. And then we gave you a cite as well to some direction in regards to some of those kind of things. So then it's a matter of what else is coming. That's what we knew as we were working through the end between the holidays. But well, we've had some other changes within the last day, like a complete change in administration. Jill and I can both tell you historically that as administrations change, the employment law aspect of life changes, and we never know how much it's going to change, but there isn't any question good, bad, or different, regardless of how anybody feels about it, we're going to need to stay in touch for a while here and work through just to see what it's going to be versus what's been talked about, what's been, and then what's going on. Okay. So, Jill, you may have more knowledge into this, so I'm going to turn it to you a little bit with some of this, but at least start with it, the rescue plan and some of the proposals that are out there. In fact, maybe I know that you've been working on this and up to speed. You want to just pick that up? And
Sure, you bet. So a week ago, the Biden team, which was not an administration yet, but a team, rolled out what they call the American Rescue Plan. It's quite massive, but they're specifically with regard to leave, there are specific provisions at this time. We don't have all of them, but what we do know is that what's going to be proposed, and again, this has to go through Congress, and then it will have to go through rulemaking, and then it will be changing at the DOL like it did in March multiple times. So yes, we're going to all have to stay on top of it, but I think it's important to just be aware that it's going to be extending the leave through September 30 of 2021. So basically it's going to be like the Family First Act that just expired, but it's going to be more expansive, and that's probably no surprise. So again, some of the provisions are tax credits are going to be extended for employers under 500. However, the difference is that the leave will apply to all employers. It's only the employers who are under 500 who will get the tax credits. It will amount to 14 weeks somehow. We don't know what that combination is yet or what they're going to propose it is. And then it will, I'm sure, change when it goes through Congress. The maximum payment, which was much lower under the last act that just expired, is now ramped up to $1,400 per week possible that an employee could get on leave. And it critically, it eliminates exemptions for small employers. As I said, it covers all employers. It also eliminates the exemption for first responders, which is for government clients is going to be more significant, and also for certain healthcare employees, but we don't know exactly what that means yet. So the other piece that is for government, local and state governments, they would also be getting reimbursement. We don't quite know what that looks like yet, but that's pretty significant. So what do you do with that? I guess as Jim said, and I will repeat, is I would follow this. We will be publishing on it, I'm sure, through its various iterations. But just be aware that that's out there. If you're looking at extending a leave, and I think this is kind of the takeaway, if you're going to extend paid leave in any way, make sure you put a sunset clause in it, maybe to prevent you from having to once again change it or reissue. And you may have to do that anyway, but make sure that you have some kind of fail-safe in there so that you're not having a situation where you have double leave if this new leave comes into play. And so I would suggest set a deadline possibly for an automatic expiration of the leave, or again, reference in your leave policy. Just be very careful to reference in your leave policy that you have, if there's new law that comes into play, it will replace the leave you currently offer voluntarily to your employees. So
before we
that's basically what I would suggest on leave policies. Jim, do you have any other input on that?
No, that's exactly right. And again, the caution, just to restate it again, is you want to reserve the right to change it, eliminate it, so that you're not duplicating. Keep in mind, when that first law passed, it said that the federal law is going to be in addition to, and you can't piggyback them. So if you gave sick leave or vacation or others, it's going to be separate. So if you give this leave, you got to be able to end it just on that. Let's just do a quick note. It's not in the slides, but we were talking also about masks because it came up yesterday. And then more recently, the governor extended for 60 days, that mask ordinance. And then President Biden first day implemented the federal one, but just to clarify, that has to do with federal property, federal buildings, things like that. So that's not going to have the same reach that the state mask application does. And again, just a quick update. We don't have a slide. Some of this just changed. And we were talking about it before we came on this morning. But the other aspect of things to talk about is what's going on with vaccines. And again, Bill, why don't I turn it back to you on that? We'll talk about it.
Yeah, this is a fraught topic. For example, I talked to a client yesterday for an hour and a half about masks about vaccinations and what to do in solutions. And it is, I would say that in terms of gray areas and topics, this is one in my 20 years of practice that to me presents one of the largest gray areas. And that may not, you all may not like to hear that, but I do think it's a matter of weighing your workplace. And because you've got, when you're looking at masks right now, you've got public health and imperatives, you've got liability concerns, and you may have a workforce that is opposed to mask mandate. We know that about at least 30% of employees are opposed to vaccination mandates. So when I talk with clients, what everybody's talking about is, do we do mandatory vaccination policy? Are vaccines really necessary for our workforce? Do we believe they are? And it is partially culture. We got an EEOC guidance, and that's really the starting point, where the EEOC guidance that was just issued indicated that employers can mandate vaccination. And that, of course, is subject to religious and medical disability exemptions. So in light of that, those exemptions in and of themselves create legal issues and they create administrative burdens. So as you look at, do you mandate, do you not mandate? One thing to be aware of is that there will be employees who will claim a disability exemption, or they will claim a religious exemption, and that in and of itself requires an employer to have in place some type of way to evaluate those exemptions. So that takes time. It also can create liability, because if you deny an accommodation, which is what that would be, it would be a religious accommodation from a policy or a disability accommodation, then you have potential liability for failure to accommodate. So that then creates some areas of concern in terms of legal costs and time, personnel time around that. So that's an issue. Medical screening, if you're putting in place a vaccination program, and actually whether it would be mandatory or whether it would be a voluntary program, there are concerns around whether you're doing the program yourself on site, whether you're using a third party, whether you're encouraging employees to use their health plans and go outside. I would say that if you're doing medical screening, you always have a exposure around learning information that you really should not be learning regarding disability, possibly, or genetic information. So it's really recommended that even if, no matter what form you put it in, you may want to consider having third parties do your program for you. The other, we might want to go back just a second. Oh, never mind. We'll do this. These are other considerations that you may have, and those would be, so I guess what I'm talking about is doing an administration plan, using third parties. One of the other issues, and I was talking with a client about this yesterday, is how do you get buy-in if you're going to do a voluntary program, but you want to get the majority of your workforce vaccinated? How do you make that a positive? And part of that, I think, is education and training, so that there is as much education as possible for your workforce. There's also considerations of incentives that I'll talk about in a little bit. But the other piece is, how do you kind of plan your PR to your workforce so you don't have conflicts, or you minimize your conflicts? So that is a consideration for you. One of the considerations, I think, though, also is, when you're weighing vaccinations, there might be legal claims from denying accommodation requests, or if you take actions against somebody because they refuse to get the vaccination. Weighing on the other side, and I just raise this so you're aware of it, is COVID-19 is recognized by the EEOC as a direct threat in the workplace. There are considerations in Wisconsin for employers of the Safe Place statute. There's also OSHA considerations and the general duty clause. So when you're balancing whether to require your employees to have it, or even instituting a voluntary program, those laws that require you to have a safe workplace really do need to be considered, and kind of as inspiring you to take steps to make decisions on vaccinations one way or another. Of course, right now we have in front of the legislature at least one piece of legislation, possibly two, and one is being considered today in the executive committee, and that is to ban any mandatory vaccination program for any employer. So if you're looking at programs right now, it may be in your best interest to consider an incentive program, a voluntary program, pending what happens in the legislature in Wisconsin. I think there's a couple other pieces to this, and that is, if you put a program in place, you want to make sure to get the biggest bang for your buck in terms of incentive, in incenting people, is you want to make sure that you eliminate vaccination costs. If you're going to have somebody getting vaccinations, allow for them to take paid time off, maybe limit it to an hour, depending on where you are, for somebody to go get a vaccination. And also continue, though, I think, to have in place your own policy about PPE and masking, in light of the fact that we don't want to prevent people from wearing masks if they want to. And that usually isn't the issue, but you want to continue to allow people to do what they need to do to feel safe. I think the next slide would be good. So there are so many issues around vaccinations that I wanted to just give at least one vignette, one example, and so to see what the issues are. And so in this vignette, we've got somebody that has an assisted living facility, and they institute a mandatory requirement that somebody must be vaccinated by March 31st, and all remote employees have to return to working in person after that date unless they have an exemption. You've got an employee, he's in the billing department, and he's been working at home as many of us have been since March 2020. And he says, I've got shortness of breath. I was hospitalized the last 2 times I had a flu vaccine, and he wants an exemption and to continue working from home. The question is, what do you do with this employee? Do you assume automatically, he says he was hospitalized, so, and he had shortness of breath. So does he automatically get an exemption because of a medical condition? And what I would tell you is that when you're looking at accommodation or disability accommodation, because we have COVID doesn't change the analysis. So if you had a situation where an employee was asking for any other change, let's say Stephen was asking for a different change. Let's say there wasn't COVID and he was asking to work from home and claiming a condition that he had based upon that. You do the same analysis. He would have to have medical evidence that his shortness of breath was not just a panic attack because he doesn't like needles. And maybe he was hospitalized because he had a panic attack because of needles. You know, maybe if he wasn't hospitalized when he had, you know, a vaccination, but he just got out of, you know, just had shortness of breath, would you then give him an exemption? So it's you look for, identify whether somebody has something that would be a disability. What can you do to accommodate that disability? In this instance, maybe for Stephen, he does have reactions to certain kinds of vaccines. Maybe he has reactions to eggs. Maybe he has other reactions. And you look to see what kind of accommodation can you give him. So
Jill,
many thoughts on that?
Jill, one of the terms that you used was direct threat, and you and I know that that's a term of art, and when the agency determines something to be a direct threat, that carries some weight, and it means it has different implications for us as employers. So can you talk just for a minute about what's the importance of that? What does that mean when they determine that COVID was a direct threat?
Well, COVID is a direct threat because it is something that does not, it's kind of a difficult analysis, honestly, but it means to me in this context that COVID-19 presents a risk of harm to the employee or others based upon that medical situation. So someone with COVID, their condition may constitute a threat to the safety or well-being of other workers.
So if we took other disabilities or other situations that might come into play, depending on when we're analyzing the accommodation, we're dealing with the fact that this issue is a direct threat, which gives the employer a little bit more leeway to take some precautions, if I could, and I really simplified the whole analysis with that. But it is a term of art that matters, because when something's in the workplace that way, one, we may have liability issue, but it also allows us to we have more leeway to make some decisions and to do some things. And we're going to get some scenarios like this guy, and you're going to get to that a little bit, but we'll talk a little bit about what if somebody gets the medical scenario that they just cannot take the vaccine. They're more than willing to come to work, but I'm just not taking the vaccine. And then how's that going to play? But we're going to work through that a little bit.
Well, and to that point, though, in direct threat, so that would be one of the challenges So you've got this person, you've got a person, let's say, who does want to come to work. They can't take the vaccine. As an employer, then you'd have to show, well, them just being present in the workplace constitutes a direct threat. And I don't see that happening. I don't see how that proof could be made. Now, if that person has exposure, or they have symptoms, or they have a diagnosis of COVID, then obviously that person constitutes a direct threat and they can't be in the workplace. But I think as I look at vaccines, that's the challenge. And I think that that's going to be really worth consideration. If somebody can't get a vaccination, you make a determination that it's all going to be incentive and 30% of your staff doesn't want to get vaccinated, then you have to have an analysis of what can you do to prevent other harm, and also then what steps do you take when somebody has exposure, and it may be no different than what you're doing right now.
Sure, but at some point where we may get to the analysis, and again, very fact specific. The point is, for starters here, is don't assume that you can just tell somebody they either don't have a job or can't come to work because they can't take the vaccine. So just a heads up with that. There's more analysis that has to go with that. And the greater degree of harm, the greater degree of exposure, the greater degree of working with populations that are more susceptible to catching the disease, there's a stronger argument about doing something about not coming to the workplace. But it's not a given, and that's the analysis and what we want you all to know. There's a little more work to be done on that. Don't just assume no vaccine, not coming, not. So let's take the other scenario for a minute, where somebody does not want to take or is advised not to take the vaccine. Well, let's say for the sake of discussion, a pregnancy situation, and I'd like to be either working at home or not working for a period of time because I'm concerned about it and the doctor's concerned about it. And again, you got to work through that analysis. So what's the exposure? What's the other pieces? I assume, Jill, it's just you got to take a case at a time, fact at a time, disability at a time.
Yeah, I mean, you have to do the same analysis. And as I said before, and especially with the EEOC, a pregnancy, really that analysis needs to follow the same as a disability analysis based upon a existing law right now, at least at the federal level. And you look at what that limitation is. I know that, for example, I had early on in the pandemic, I had a situation where there was an individual in a medical setting who was pregnant, and we ended up asking her physician, the physician said, well, I don't think she doesn't really want to be there. She wants to be more distant and she doesn't want to wear a mask and she's pregnant. And so that supports, because she's pregnant, that you should allow that accommodation. And what we really had to do was to drill down on that limitation. Why can't she be why can't she be around patients in a patient-facing job with, as opposed to how can she be around coworkers? What I found, and I don't know, Jim, you probably have too, but there are right now the issues around physicians and medical providers providing excuses kind of willy-nilly on, I'll say disability in quotes or limitations is a little bit problematic because I've found that is a growing cottage industry right now to provide excuses around masks or around, now it will evolve into vaccinations. So you really need to do a careful evaluation, look at whether the employee has a true limitation, whether their inability to do their job, whether, either it's a masking or whether their inability to get a vaccination is going to impact their ability to do their job. Is there another way they could do their job without having a vaccination? And that's the ultimate accommodation question. Is there a way that that individual can safely and effectively perform their job with another accommodation, which might be working at home, for example, continuing to work at home. So, and that's in our scenario, that's what Stephen really was looking for. He was trying to continue working at home. One of the other things that is recent, very recent, actually last week, was the EEOC issued some clarification on wellness programs. And that is being tied into the concept of a vaccination program. What the EEOC has said is that they have proposed regulations on this, is that if an employer provides de minimis incentives then to employees, then and under any basis for wellness, that then does not become a health plan, because the rules are basically that if you're providing more than de minimis incentives, that's going to be considered to be a health plan. And so that's woven into the discussion about whether a vaccination program is really a wellness program, because it goes, excuse me, goes to incentives. So let's say you want to put in place a voluntary vaccination program. Those rules out there right now, proposed rules, don't specify whether a vaccination program is a wellness program, but it may be in an employer's best interest to consider that it is potentially a wellness program. So someone just asked the $1 million question, which I was going to get to, and that is, what's de minimis? Well, the EEOC's regulations give us a range. They say gift cards are de minimis, a year's enrollment in a gym, a year membership of a gym is not de minimis. There's a pretty wide range between a $10 gift card and a year's membership at a gym. And they don't provide us any more information than that. So one of the things I was doing with our client yesterday was trying to figure out what would be de minimis. And so I apologize, including to the person who just asked that question, because we don't really know. We know that you can't say to somebody, you can't give them $500. That's clear, that's not de minimis. But is, 4 hours of pay, is that de minimis? Well, it depends upon the size of the employer. It depends upon what your employees are paid. Dollar General has a program right now where they're paying employees for 4 hours. But if we assume that they're paid, Dollar General employees may be paid slightly more than minimum wage, that's like $40 or $50. So I would say that, they don't define de minimis as, is it within the context of what the employee would normally get? We only know de minimis really from the Fair Labor Standards Act. So this is a very different concept for the EEOC to be putting in play right now. Jim, do you have thoughts on that?
No, and I agree, and that's where we come up with it. De minimis is how much extra time might be compensable if it's a little bit. working off the Latin phrase that we're working with, and lots of case law in terms of what is just a little bit of extra time that maybe kick us into compensable time or not. But it's interesting they use that phrase in this context because it's different, but that's the other context we see it in. So
Yeah.
the thing is they're saying you can do something, you can give an incentive without falling into being a whole plan, but be careful. Okay.
Well, and that's the thing. They didn't speak specifically to vaccination programs. And that's the most troubling. I mean, because that's really the ultimate first question, but they haven't answered it yet because these are just proposed regulations. But if, as an employer, if you're trying to set up a program right now, a vaccination program, and you're trying to incent employees right now, I would just keep in mind that those rules are out there and they may determine that they do apply, that a vaccination program is a wellness program. And so, because obviously it goes to health and it goes to wellness. And so, it may be you say, well, for our employees, if they're paid $50 an hour, which would be a lot, but let's say they are, well, maybe an hour to get a vaccination is okay, but maybe you can also do a gift card, but a gift card that's going to be, over $50 that seems pretty significant. A $50 gift card for somebody who gets minimum wage is, to me, far more than de minimis. So you kind of have to consider your culture, your pay scale. Also, when we were talking yesterday, the question was, or the thought was, go back to the manager and say, what will incent employees in this workplace? And getting buy-in, sometimes it's best to, you can leverage a manager or a supervisor or poll employees, get an advisory group of employees to say, okay, we want to, if you're a large enough employer, we want to do this program. What is going to incent people? What's your feedback on it? It's the time to kind of tap into your employees, give them a voice on this without having them define what you need to do. But I think it's something to consider if you're trying to put a voluntary program in. The other piece in terms of a vaccination program, if you're going to have one, a really well-crafted policy is highly recommended. And also just keep abreast of what's going on, state, federal, local mandates, because short of OSHA declaring for private employers that their vaccinations have to occur, these issues are going to stay out there. Jim, any other thoughts on that?
No.
Okay.
I agree.
I thought we could throw in one of my favorite topics, which should be the next slide. Just talk a little bit about FMLA. Jim broached it on the front end with the thought that if you're crafting an extension of the emergency family leave, that you don't want to create, you want to understand that isn't FMLA qualifying. But one of the other issues that I see a fair amount, and I'm still, 9 months later talking to employers about, is whether a condition is FMLA, whether the COVID-19 is FMLA. So I have a vignette here, and we have an architecture firm, and they brought their staff back to the office. But George now tells HR that he's been diagnosed with COVID, and he wants to take FMLA time. The second piece is we got Marielle, and she's fearful. Same at Strong. She's also at Strong Architects. she's afraid that if she gets COVID, she'll have serious complications because of her asthma. So she wants FMLA time off to avoid exposure. The question is, which of these requests does Strong have to grant? Do they have to let George take FMLA time because he's been diagnosed with COVID? Do we need to let Mariel take FMLA time because she's got a medical condition and she wants to avoid exposure? Well, the answer is on the next slide, probably neither. So first off, just a COVID-19 diagnosis standing alone is not a serious health condition. There are criteria for serious health conditions, and those require medical intervention and treatment or 2 visits to a doctor or a medical provider. And so standing alone, the diagnosis is not a serious health condition. You can't take FMLA to avoid exposure. Now, that may be a disability accommodation analysis, and that may require, Mariel may require entering into an interactive process with her. But it isn't FMLA to avoid exposure. It's not FMLA when somebody's quarantined, unless they're quarantined because they have COVID, and the COVID, they have met all the requirements for a serious health condition. And now there's no FMLA for parents who have to stay home with their child because of school closures. At least for now. Let's remember back a few slides about the proposal that's going to head to Congress again. Or unless you, and even if you extend the emergency family medical leave, that still doesn't qualify now for FMLA. So there's some guidance on this slide, questions about FMLA, and there's a lot of questions and answers at the site, and I would recommend going to it if you ever have questions about FMLA.
And I can add to that, Jill, you know, even as we follow the Q&As that the DOL has come through under the FFCRA and others, they really only added 2 more that we're aware of, and they pretty much just talk about what we talked about in the beginning part about how it's ending and how there's no guarantee of it going forward, but they'll enforce what exists or is already in the bank as far as that goes before the end of the year. So there's not a lot on that piece of it yet from the Q&A pieces, but we'll wait and see. As we were talking about a little bit earlier, and we gave you a little bit of some of the stuff that's coming and some of the stuff that they said, but that is, we're always cautious to go too far with things that are pending. And the same on the state level, as we started to talk a little bit about, you know, might they put in a provision that won't allow requiring for vaccines? Well, that's being debated, but we don't know where that's going to end up. So we're always a little hesitant so we don't confuse what we got to do versus what we might do. When I say that, we're clearly working on the program we do annually with the congressional office, with the Senate office, and with Gordon Hintz, Congressman Grothman, Senator Johnson's office. We're updating that program in communication with those folks to put that program together. Normally we do it about now, but the way things are developing, we got to give it just a little bit more time because of all the action that's going on right now in DC and the state. And they'll definitely be reporting out to us to have that panel discussion coming up probably within the month or 2. So stay tuned for that. We didn't want to get too far into that today because we're going to do that program with those folks as the panel, as we do annually every year. Very popular program, very well attended program, and really insightful to hear their comments from different sides of the aisle, quite frankly, as to their views and the aspects of that. And then when I say that in terms of Gordon Hintz's position versus, you know, some of the others on some of that. So it's helpful. So stay tuned. We'll get that information out. Jill, I am not seeing, I'm just checking the Q&A, but we can open up to any questions or concerns people have. And even John Casper, I'm not opposed to if we want to unmute for some of that debate for a little bit. We do have a little bit of time.
Yeah, and Jim, while we're waiting for that, to your point, and I think I broached this at the beginning. These are evolving areas. They're gray areas. We know, and I guess the biggest takeaway for anyone looking at vaccination programs, right now we're kind of functioning with a shortage, so you may have time, but it's worth thinking about is just approaching anything you do with caution in terms of mandates, but also when you're putting together any policies right now, build flexibility, put flexibility in them, because I think we will see changes evolving. I mean, we saw last March, even the DOL, as they rolled out the initial leave policies or leave programs, they changed. The game changed as we went along. We ended up with, I think, over 110 guidances, questions and answers, because we kept feeding questions to the DOL and they kept responding to them, which was helpful. But within legislation, there's, if it moves quickly through Congress, a lot of things aren't addressed. So we try to stay on top of them. And I guess what I would say is if you have questions, wondering about a specific program you might be putting in place, it's probably helpful to reach out to your legal counsel, to us, and say, what do you think about this? Because we're all in this together at this point in time. So, but I think it's helpful for you to see what's potentially on the horizon. But don't forget your basics that you would normally do in terms of functioning. And that's one of the reasons I wanted to talk about FMLA. FMLA is what it is. Disability law is still the same. None of that has changed. So you still have all those obligations.
Jim, so I've unmuted everybody, I guess. I gave them the opportunity to, if they have a question, they have to unmute themselves to ask that question. So if anybody has something they would like to add, something to ask, you can do it now. Again, or you can use the Q&A tab on the bottom.
Anybody got a question or a comment or a war story that the company next door has that it wouldn't be you, but that you heard about? We're open to that. We learn a lot of these too. So. Any comments or questions? If none, then stay tuned, because we will continue to update to the other aspects of things, and we'll have another program next month for sure, and we'll roll in the legislative piece as soon as we can do that. That's timely, and keep you all updated. So, John, again, thanks to the Chamber for putting the program together, and let us know.
Thanks all.
Thanks again to Jim and Jill and Von Rees and Roper for doing these programs. They're great programs for us. I know we had great comments from those that listen in and go back later. So we appreciate that partnership, be able to provide great quality programming like this. Ever-changing environment we're in, so do stay tuned. I think our next HR briefing is on the 18th of February, third Thursday of each month. So we'll be looking for that. We'll be coming up with that topic within the week or so. So be looking for that. So with that, I will say goodbye to everybody, and again, thank you for joining us.
Thank you. Bye now.
Thank you.